කල් තැබීම
ගරු කථානායකතුමනි මෙම දරු සභාව 2012 සැප්තැම්බර් මාස 18 වෙනි අඟහරුවාදා පස්වරු 1 දක්වා කල් තැබිය යුතුයි යෝජනා කර සිටිනවා.
කල් තැබීමේ යෝජනාව කරු රාජවරෝදයම් සම්පාදන් මහතා Honorable Mr. Sampadan, you have to move.
Thank you, Mr. Speaker. If I might read the adjournment motion I'm moving today.
Order, please. Deputy Chairman of Committees will take.
Yes, Honorable Samman.
Thank you, Mr. Deputy Chairman. Whereas more than 3 years have elapsed since the conclusion of the war on 19th May 2009, during the course of which grave violations of international human rights laws and international humanitarian laws occurred. And whereas since the conclusion of the war, the following significant events have occurred. One, the joint statement issued by His Excellency the President on behalf of the Government of Sri Lanka and the Secretary General on behalf of the United Nations on the conclusion of the Secretary General's visit to Sri Lanka on 23rd May 2009, which inter alia stated as follows. One, Sri Lanka reiterated its strongest commitment to the promotion and protection of human rights in keeping with international human rights standards and Sri Lanka's international obligations. The Secretary General underlined the importance of an accountability process for addressing violations of international humanitarian and human rights law. The government will take measures to address those grievances. Two, President Rajapaksa and the Secretary General agreed that addressing the aspirations and grievances of all communities and working towards a lasting political solution was fundamental to ensuring long-term socio-economic development. President Rajapaksa expressed his firm resolve to proceed with the implementation of the 13th Amendment, as well as to begin a broader dialogue with all parties, including the Tamil parties, in the new circumstances, to further enhance this process to bring about lasting peace and development in Sri Lanka. Three, two, the appointment by the Secretary General of a panel of experts on 22nd June 2010 to advise him on the implementation of the joint commitment included in the statement issued by the President of Sri Lanka and the Secretary General at the conclusion of the Secretary General's visit to Sri Lanka on 23rd March 2009. In the joint statement, the Secretary General underlined the importance of an accountability process, and the Government of Sri Lanka agreed that it will take measures to address those grievances. The panel of experts, in their report released on 31st March 2011, stated inter alia in their conclusions, the final stages and aftermath of the war in Sri Lanka were characterized by a wide range of violations by both the Government of Sri Lanka and the LTTE of international humanitarian law and international human rights law, some even amounting to war crimes and crimes against humanity. More than 300,000 people became the victims of the reckless disregard for international norms by the warring parties. Indeed, the conduct of the war by them represented a grave assault on the entire regime of international law designed to protect individual dignity during both war and peace. The victory of one side has emboldened some to believe that these rules may now be disregarded in the cause of fighting terrorism, para 258 of the report. 3. The appointment by the President of Sri Lanka of the Commission of Inquiry on Lessons Learned and Reconciliation, LLRC, on 15th May 2010, which submitted its report on 15 November 2011. The recommendations contained in the said report, inter alia, included the need to credibly investigate widespread allegations of extrajudicial killings and enforce disappearances, demilitarize the north of Sri Lanka, implement impartial land dispute resolution mechanisms, re-evaluate detention policies, strengthen formally independent civil institutions, reach a political settlement involving devolution of power to the provinces, promote and protect the right of freedom of expression for all, and enact rule of law reforms. 4. The adoption of a resolution by the United Nations Human Rights Council at its 19th session on 22nd March 2012, which inter alia noted, 1, that the LNRC report does not adequately address serious allegations of violations of international law. 2, called on the government of Sri Lanka to implement the constructive recommendations in the LNRC report and take all necessary additional steps to fulfill its relevant legal obligations and commitment to initiate credible and independent actions to ensure justice, equality, accountability and reconciliation for all Sri Lankans. 3, request that the government of Sri Lanka present a comprehensive action plan as expeditiously as possible, detailing the steps the government has taken and will take to implement the LNRC recommendations and also to address alleged violations of international law, and also request the High Commissioner for Human Rights to present a report to the Council at its 22nd session, due to be held in March 2013. 5. The release by the Government of Sri Lanka of a National Action Plan to implement the recommendations of the LNRC. This action plan has not been formulated after due consultation with Parliament or the democratically elected representatives of the affected people. It is in this background, sir, that this whole issue in its totality, which is directly linked to genuine reconciliation, goodwill and harmony amongst the different peoples that constitute the Sri Lankan polity, becomes an issue of urgent national importance that needs to be kept under the close and continuous scrutiny of the country's democratically elected Supreme Legislature. That, Mr. Speaker, is my adjournment motion. And we might now, sir, deal with some aspects of this motion, with your permission. I would, in the first instance, state that I would first like to deal with some actions of this action plan which has been released to the public. It is not my intention to discourage those who are tasked with the implementation of this plan, or to say or do anything that would result in the plan not being implemented. But if there are deficiencies in the plan, I think we owe a duty to point out those deficiencies. And if we think that there are corrections that need to be made in regard to the manner of its implementation, I think it's the correct thing for us to bring that to the notice of the government, particularly the notice of Parliament, to ensure that the objective of the resolution passed by the United Nations at its Human Rights Council, that in order to ensure harmony, certain things need to be done. In order to ensure reconciliation, certain things need to be done, and those things need to be incorporated in an action plan and implemented. I will deal with some aspects of this action plan, sir, not with all of them, but with some aspects. One of them talks of appointing a special commissioner of investigation to investigate alleged disappearances and provide material to the Attorney General on that question. Now, very unfortunately, the action contemplated does not seem to contemplate or does not seem to indicate that a special commissioner would be appointed. The action plan contemplates some other action which is not the same as a special commissioner being appointed with special powers and with special investigators to deal with this question. The second matter relates to appointing an independent authority, independent committee to monitor and examine detention and arrest of sections of persons taken into custody. Here again, an advisory committee is not being appointed, and what is being contemplated is a totally different type of action.